Hello and a very warm welcome to this webinar this morning on tantrums, troublemakers and trust. I'm Jenny Arrowsmith. I'm a partner in the employment team here at Irwin Mitchell, and I'm joined by my two colleagues, Laura Willis, who's a senior associate in our Midlands team, and Poppy Ford, who's a solicitor in our Southern team. Myself, I'm based in the Northern team. So together we're going to be presenting to you today about this topic, which seems to have been really, really popular, which I think suggests that you're all very much dealing with tantrums, troublemakers and trust issues within the organisation. So we're going to be talking about people who are never happy, people who take up significant amount of your time with challenging behaviour or maybe objections. Perhaps you've got those cases of people where there's conduct issues, but perhaps not necessarily high enough to reach a disciplinary threshold, but where over a persistence of time, trust is just undermined and you just feel that they are issues that need to be dealt with. We've had them described to me before, and actually someone in the registration form asked a question about what they described as mood hoovers, which I like the phrase of mood hoovers, those people that you really struggle with. So we're hopefully going to give you some answers in terms of how to deal with these kind of situations today. Poppy's going to start off talking about general principles, and then Laura will talk through one type of scenario that we've identified as common, which is difficult personalities. I'll then talk about trust and confidence and third-party pressure. And then importantly, like any dismissal, we need to talk about the fair procedure that you need to follow. So we'll be talking about that too. Poppy will guide you through that towards the end of this session. As always with these, if you've got questions, please do put them in the question and answers chat. We will do our very best to deal with them throughout this session. If we don't get to them, we will try and follow up if we know who's made the comments directly after the event, but we will try and deal with them as many as possible. We also thank you for putting some questions through on the registration forms. We think we are going to be able to deal with most of the general ones in the course of this session. And finally, from me, by way of introduction, feedback is so important to us. There is a feedback form which you will see being pasted into the chat area now shortly. Please can you take just a few minutes to give us some feedback on this session? It's a couple of minutes just to fill it in. In particular, we're looking at our events programme for this year, and we're really keen to hear your feedback so that we can make it as relevant to you and the issues you're dealing with. So a bit of a plea from me on that front. Okay, so without further ado, I'm going to hand over to the very lovely Poppy, who's going to start it off looking at what do we mean by SOSR. Poppy.
Thank you, Jenny, and good morning, everyone. So we thought it would be helpful to just kick off the session with a reminder on the general principles that apply to a dismissal. So where an employee has 2 years service, they have the right to not be unfairly dismissed. So that means that there needs to be a potentially fair reason for the dismissal. And if there's more than one reason for the dismissal, the principal reason needs to be a fair one. So just as a reminder, there are 5 potentially fair reasons for dismissal, and some other substantial reason, often referred to as SOSR, is one of those. So if the reason for dismissal is some other substantial reason, the employer will need to be able to justify the dismissal of an employee holding the position which the employee held. So basically that means that it's relevant what role the individual is in and the nature of their work as well. And then the decision to dismiss must also be reasonable in all of the circumstances, taking into consideration the employer's size and also their administrative resources. Employers will only be seen to have acted reasonably if they also follow a fair procedure. So we'll come on to that later. If we could move on to the next slide, please. Thank you. So where an employee is dismissed because there's a breakdown in working relationships, the reason for their dismissal may be some other substantial reason. And we're going to be exploring some of the common issues that lead to a breakdown in relationships today. But before we do that in a bit more detail, as a helpful reminder, for a breakdown in relationships to amount to a fair reason, that breakdown needs to be serious enough to mean that a lesser sanction isn't appropriate and the dismissal needs to be justified. So really what that means is that the employer is expected to take reasonable steps to try and improve the relationships, and we'll come on to what that might look like later, for example, mediation. And the employer also needs to be considering whether the relationship has deteriorated to such an extent that the employee cannot be reincorporated into the workforce without unacceptable disruption. It's also important that the dismissal is not, in reality, rooted in an unlawful reason, for example, discrimination. And so it's really important that you carefully consider why the relationship has broken down. And again, we'll be exploring that in a bit more detail today. And finally, for it to be a fair reason, it needs to be the sole or principal reason for the dismissal as well. Okay, if we could move on to the next slide, please. So, as we said, in this session, we're going to be covering some of the common examples which fall or might fall into the category of some other substantial reason. So, type 1, this is the employee's difficult personality and where that causes a serious breakdown in working relationships with colleagues. So, Laura will be covering this topic very shortly. Then we've got type 2, which is loss of trust and confidence in the employee due to problems in the working relationship. And then type 3 is where a third party pressure, and that pressure is in place from the third party to the employer to dismiss the employee, sometimes because they prefer a temporary replacement, or the pressure can come from other reasons as well. And Jenny will be covering type 2 and type 3 for us today. So I'll now hand over to Laura, who will explore that in a bit more detail.
Thanks, Poppy, and hi, everyone. So as Poppy has said, one of the most common reasons that we see SOSR dismissals is due to personality clashes, which cause a serious breakdown of working relationships. And I'm going to look at that in a little bit more detail with you. So when we talk about personality clashes, that can apply to different personality types more generally, but also to management style, which can lead to difficult or fractious relationships between employees. When we talk about difficult personalities, these are the sorts of behaviours that tend to cause the most problems as set out on the slide. And I will go through each of these briefly, but it's worth saying that these aren't necessarily distinct categories and some of them will overlap. So to start with, insensitivity or mood hoovers. Again, that's something that I heard for the first time earlier this week in one of the pre-submitted questions, so I've been really enjoying it. But here we're usually talking about people who cause a bad atmosphere and they can suck all of the joy out of the room, those are your mood hoovers, or those who are permanently negative and affect group dynamic and cohesion, ultimately making them less productive generally. Brusqueness or being dismissive of other people or their opinions can cause problems both with colleagues but also third parties. And it's this type of behaviour that often leads to complaints about those employees or the organisation itself. Those who are forceful or stubborn have a view that they're right and others are wrong, and there's no changing their mind. And that's often in situations that aren't necessarily black and white. The issue being they won't change their mind and either can't or won't reflect on their behaviour, so nothing ever changes. We also have the type of individual who is blunt or antagonising in the way that they speak to others. And it's these types of people who have no sense of compromise and they're inclined to raise a lot of complaints. Unwillingness to accept change can also be problematic because this causes disruption to the organisation, particularly to the division in which that employee works. And then a lack of respect for the people or their opinion speaks for itself. I don't need to explain that one to you. So to recap, I'm sure that all of you are able to think of at least one person who has one or a number of these traits and can understand why these personality and management style types can, in some circumstances, be really problematic. And as I say, quite often it's issues that arise as a result of these types of people that can lead organisations to go down an SOSR route. And it's something that we do advise on quite a bit. Next slide, please, Lisa. So unfortunately, as ever in employment law, it isn't as simple as spot the problem arising from the personality type and simply dismiss the awkward individual, because personality of itself isn't a lawful ground for dismissal under the Employment Rights Act. In order for dismissal to be fair in these circumstances, an individual's personality has to manifest itself in a way that comes within the fair reasons for dismissal, and that's under Section 98 of the Employment Rights Act. And that will generally come under either conduct or some other substantial reason, which is the catch-all term for dismissals which don't fit neatly into the other categories. Now, having said that, the reason for dismissal, as Poppy has said, can't be both misconduct and SOSR. It either has to be one or the other. And as the slide says, generally when we are advising our respondent clients, we would plead either misconduct or SOSR as the primary reason for dismissal, but then say in the alternative, so essentially if the tribunal disagrees with our analysis of the fair reason, we contend it was the other. So we're essentially hedging our bet, so it's open to the judge to determine that they agree with one of our proposed reasons, fair reasons for dismissal. But ultimately it is for the tribunal to decide. So deciding which fair reason for dismissal applies is important at the point we start the process towards exiting an employee. And that's because there are different implications in terms of procedure depending on which route you go down. Now, as Poppy mentioned briefly, unfair dismissal claims are split into substantive fairness, so the reason for the dismissal was fair, and procedural fairness, which means the correct procedure was employed and it was followed correctly. So if we take misconduct first, for an employer to establish a fair conduct dismissal for those who have more than 2 years service, they have to have followed the Acas Code on disciplinary and grievance procedures, which sets out what a fair process looks like in terms of hearings, investigations, the right to be accompanied, and the rest. Failing which, employees can make a claim for procedurally unfair dismissal and claim an uplift of up to 25% on damages as a result of the failure to follow the Acas Code. For misconduct dismissals, employers also need to apply the range of reasonable responses test. Now, that's a legal standard used by the Employment Tribunal in order to assess the fairness of an employer's decision to dismiss an employee. So the test evaluates whether the employer's decision to dismiss falls within a spectrum of responses that's available to a reasonable employer, and that employer might have taken under similar circumstances. So it's not about whether the tribunal would have made the same decision in the employer's shoes, but whether the decision was one that a reasonable employer could have made in the situation that it was in at the time. So turning to SOSR, the range of reasonable responses test doesn't strictly apply to those dismissals, and the Acas Code doesn't usually apply, but there are some exceptions that will come on later, so I won't steal anyone's thunder. There also isn't necessarily a set process for SOSR dismissals in the same way as for the disciplinary process, but there might be some similarities. So, for example, inviting the employee to a hearing, allowing the right to be accompanied, hearing out what they have to say and conducting an investigation, but there aren't sanctions imposed in the same way as for a disciplinary process because SOSR applies in the absence of any other fair reason, but a fair process in the circumstances still needs to be followed. So in particular, there will be a positive obligation on the employer to consider alternatives to dismissal, and that will include consideration of whether the employer could have reasonably organised its business in such a way that avoids conflict. There was a case that demonstrated this point really well, that being SA Brain and Co. against Philippart, which is an employment appeals tribunal case. And in that case, the claimant was employed as a pub manager by SA Brain, and his relationship with his line manager deteriorated to such an extent that he went on sick leave and lodged a grievance. Now, in response to that grievance, SA Brain changed the claimant's line manager and he came back to work. So from that point, there weren't any further problems until a major management reorganisation, which resulted in the claimant's original line manager being reappointed to that role. Now, in its decision, the appeals tribunal's view was that the employer could have reorganised its business in a way that avoided the claimant being managed by his former line manager, and therefore its SOSR defence to the unfair dismissal claim failed for lack of procedural fairness. So whilst that is a good illustration of what's expected in terms of seeking alternatives to avoid issues arising from personality clashes, we do recognise that this type of reorganisation solution is probably limited to a breakdown in relationship with just 1 or 2 people, unless your business is big enough to make wider adjustments. And it also wouldn't necessarily be appropriate if the problem is inherently with one individual, such that by moving them, you just move the problem. And it is at that point that we'd be advising you consider a dismissal for SOSR. So we're moving on to a real life scenario now. So I'll read this to you. And Lisa, if you could move the slide along as we go, please. So Mr. E was a surgeon working in an NHS trust. He made a number of complaints about his colleagues over 2 to 3 years and about shortcomings in the way the department was run. He accused 2 colleagues of fraud and accused others of incompetence and of jeopardising patient care. His colleagues complained, resulting in an internal inquiry, and a finding that his comments were, and this is quite damning, excessively frequent, unacceptably detailed, and unrelenting to an extreme degree. So 9 senior members of the department collectively wrote to the chief executive to express their grave concerns about Mr. E. They said that there was a complete lack of confidence in and a total breakdown of the relationship between Mr. E and senior staff within the department, and they threatened to resign if they had to continue to work with him. So the investigation found that there was an irretrievable breakdown in working relations and that Mr. E was largely to blame. The trust dismissed him for SOSR without following its contractual disciplinary procedures. So, my question for you is, was Mr. E dismissed for causing the breakdown in relationships, in which case we'd be concerned with a conduct dismissal, or because those relationships are broken down, in which case we would be looking at SOSR? So this is the case of Isaias against North Glamorgan NHS Trust from 2011. And again, this was an Employment Appeals Tribunal, an EAT case, and it went all the way through the system to the top. So in their judgment, the EAT acknowledged there's a fine line between conduct and SOSR, but they did conclude that Mr. E had been dismissed because the relationship had broken down, which then put the dismissal within the SOSR territory. They found in particular that the employer in this case had set out the reason for the dismissal in clear terms, and it had made it clear that its decision was not about his conduct, even though it acknowledged that a conduct dismissal was an option available to it, so that decision was key to the EAT's finding on that particular point. Now, this was a really good result for the trust because it hadn't followed its contractual disciplinary procedure, and we have to consider that if the EAT had concluded that it was actually a conduct dismissal, it would have been unfair because the procedure the trust followed didn't comply with the Acas Code or its own contractual policy, so we'd also have had a breach of contract. So that highlights not only why it's so important to get it right, but also it's vital to set out the reasoning for the SOSR dismissal and the alternatives that were considered at the point of termination, because the tribunal does take that into account. So on the next slide, we've got another real life case example for you here. Again, I'll read this to you so we're all going at the same pace. Lisa, if you can move the slide on as we go, please. So Mr. P was a director of finance in an NHS trust. He was good at the technical aspects of his job. He was considered to have integrity and he was respected by the team he directly managed. But he had a difficult working relationship with senior colleagues, and these came to a head when he was on holiday. Now, the board agreed it needed an exit strategy for Mr. P, and on his first day back, the chief executive summoned him to a meeting without warning and asked him to resign with immediate effect. Mr. P refused and he raised a formal grievance. The trust then started disciplinary proceedings against him and he was suspended during that process. During the investigation, colleagues said he was intimidating during meetings, refused to discuss issues or compromise, and they said they could no longer work with him and they wanted him to leave. In response, Mr. P accused the chief executive of being dishonest about his qualifications, which wasn't true, and of being a bully. He was then dismissed on 2 grounds, the first being the breakdown of his working relationships and the second being because of his behaviour during the disciplinary process. So I'll ask you again, was the reason for dismissal SOSR or was it conduct? Now, this was the case, in case you'd like to look it up in more detail, of Perkin against St George's Healthcare NHS Trust. And this is a Court of Appeal decision from 2005. And again, it was determined that the reason for dismissal was SOSR rather than conduct. And the reasoning for that is essentially set out in a nutshell on the slide. So the judgment said that Mr. P was in a senior position, and remember, with SOSR dismissals, the tribunal will consider whether dismissal is the appropriate sanction for someone holding that particular position, and he could not or would not work harmoniously with colleagues and outsiders with whom a harmonious working relationship is essential. So although he wasn't given any warnings and other parts of the process were deemed to be procedurally unfair, it was decided he was too entrenched in his position to change. So he is your classic intransigent employee that we looked at earlier. His behaviour during the disciplinary process was also telling. So he didn't merely have an aggressive reaction to the proceedings, which might be understandable, but his reaction by unjustifiably attacking the chief executive, the judge said, I'll just read this to you, amounted to corroboration of the accusation that he had already shown himself near impossible to work with rather than for, and reflected his dogged insistence that these attacks were justified. So again, fairly damning. As I say, there was some procedural unfairness. The reason for that being that there was evidence that the person who chaired the disciplinary hearing had already decided that Mr. P had to go. But the court said that the employment tribunal was entitled to find there was a 100% chance that he would have been dismissed, even if the hearing had been carried out by someone who was completely impartial. So both of these cases that we've looked at demonstrate that, unlike conduct cases, it may not be necessary to give a series of warnings before dismissing someone for that dismissal to still be fair. That said, if you are thinking of dismissing an employee for SOSR, we always suggest that you take advice, both about the correct reason for the dismissal, but also the process, because if you do make the wrong call and the employee has the appropriate length of service, they are likely to be in a position to bring a successful and fair dismissal claim. Next slide, please, Lisa. Now, this slide relates specifically to a pre-submitted question that we had prior to the event from quite a few of our delegates. So thank you very much if this came from you, and it is about serial complainers. So you don't need me to tell you that dealing with an employee who repeatedly raises grievance after grievance must be up there as one of the most frustrating jobs that HR advisors and the managers tasked to deal with the investigations have to deal with. Resolving grievances is time consuming, and when you add in the emotional intensity that comes along with the complaint, you can absolutely see why the energy levels of the people having to deal with it can become depleted quite quickly. So the particular question was, can you dismiss someone who raises one grievance after another for SOSR? So the first point to note on that is that you can't reject a grievance simply on the basis that you found the last 5 or so to be without foundation, or you don't like the way that it's been phrased. It is entirely possible that your employee has a legitimate grievance this time, and the unfortunate reality is that you won't know unless and until you investigate. It's also really important that although you're likely to be running out of steam, you put the same amount of effort into investigating the serial complainant's position as the others that you need to interview. Having said that, it is possible that over time, an employee who makes a number of petty or repetitious complaints will destroy the implied duty of trust and confidence between themselves and the business, which will potentially give you a fair reason to dismiss them. So if the allegations are always about the same person or the same team, it might also cause a breakdown in their relationship, in which case it would fall within the type 2 SOSR dismissal, which Jenny is going to look at in more detail very shortly. But you must absolutely warn the employee before you get to dismissal stage. And given the risk that if you get this wrong, you could make it easier for the employee to succeed with an unfair dismissal claim, a whistleblowing detrimental dismissal claim, or a victimisation claim, again, we recommend that you do take advice first. So that's me for now, and I'll leave you back in the capable hands of Jenny.
Thank you very much, and thanks for the questions. I can see them coming through, so we will pick up on some of those towards the end. But as I think you can see, it's not straightforward, and a lot of this will come down on a fact-specific basis. And that's the same with this section that I'm going to cover, which is trust and confidence. So this is the other kind of common type of scenarios where we might be advising whether there is enough to amount to an SOSR dismissal. So you're well aware that there is a duty, a mutual duty of trust and confidence between employer and employee, and you'd be most familiar with that being alleged to have been broken on the side of the employee when they may have resigned and then claimed constructive dismissal. Most often from an employer's perspective, where we're alleging that there is a breakdown in trust and confidence, it will be because of something significant of a misconduct nature, such as theft. And that obviously would be dealt with under the disciplinary procedure. But there are some exceptional circumstances where perhaps there isn't a conduct issue or performance, but the trust and confidence between the employer and the employee on the employer's side in particular has gone. And sometimes it's mutual. And I'm just going to pick up on some of those details there. And I've put on the slide just 2 scenarios. And I think the key thing from this section is really understanding that SOSR is a last resort in this instance. It's not to be used as an easier way, perhaps, of terminating where there is actually a conduct issues. And the courts in many, many cases around this are very, very clear in relation to that. In fact, one particular Court of Appeal case said that the breakdown of trust is not a mantra that can be mouthed whenever the employee relationship is faced with difficulties in managing a more conventional reason, such as conduct for dismissal. And so where employers fall under particular scrutiny is where employers are too quick to rely on trust and confidence, either as a knee-jerk reaction or perhaps to try and justify dealing with difficult employees who have just moaned about a situation that should otherwise be managed in a different way. And that's exactly what happened in the case that I'm going to talk about now, which is in relation to this dispute about salary and bonus. So you will all have had employees who have complained about salaries and bonuses. And one particular case called Handshake and Summers, it was an EAT case. There was a disagreement about salary and bonus. It's not this one, actually, Lisa. It's fine. Click back. Thank you. There was a disagreement about salary and bonus. It was a small company, and the employer essentially didn't like the fact that this individual was taking such issue with the way that he was being paid. And it was alleged that the relationship had completely broken down. But beneath that, the tribunal was satisfied that actually the real reason here was a struggle of power, effectively. It was simply a disagreement, and yes, the employer might not have liked that challenge, but ultimately it hadn't broken down trust and confidence in a fundamental way. Now, it did acknowledge, and this is hinting at some of the things that you will have heard Laura talk about, it did acknowledge that the manner in which the dispute had been raised wasn't particularly helpful, but it wasn't raised in such a way that fundamentally undermined the relationship and the continuation of that relationship. In essence, the trust and confidence hadn't evaporated, and there was still a maintainable relationship there. That's really important, and that's what we really need to be looking at from a scrutiny point of view when we're looking at some of the substantial reason. We call it the last resort, we call it the catch-all, but it isn't an easy ground-up dismissal to rely on. Now, there are instances where it's very borderline, and I can see some of the comments coming through do make that observation. You're completely right. It can be quite borderline as to whether you're dealing with a conduct issue or something more that we're talking about, which could be an SOSR. And there has been cases, including one called McFarlane and Relate, where in very specific circumstances, the tribunal were accepting that an SOSR ground had been established. And that ultimately related to an individual who was refusing to do a part of their job. But it was very specific to the circumstances. It very much was on the borderline, in my view. But ultimately, the tribunal accepted that this individual and the way he was behaving was not enabling the employer to ensure that their wider service was carried out to all its service users. He was a social worker, and it was a religious belief matter. And that trumps the conduct issues. But like Laura says, it's for the tribunal to ultimately determine. So quite often when you're calling people to a hearing in relation to a potential SOSR scenario, you might plead in the alternative, but you've got to be very clear if it is an SOS scenario that you are looking at. Okay, so moving on to the next slide then, I'm also going to give you a real life scenario just to try and put a bit of context into trust and confidence. And here I'm really picking out again this manner in which complaints have been raised and the extent to which you can differentiate that from the fact that a grievance has been raised. There's a couple of comments being made, and again, this is an absolutely accurate observation. There is a fine line sometimes between people raising complaints which might in itself be protected and that they can't suffer less favourable treatment for having raised that complaint, but then their behaviour around that complaint is the thing that ultimately chips away at trust and confidence to the point that an employer might ultimately conclude that the relationship is no longer workable. So giving a bit of context and example to that then, we've got Mrs. A. She was a receptionist and an administrator. Her employer decided to restructure and reduce its reception staff from 3 to 2 and change the job description to include other duties. It held competitive interview process to determine who to appoint from the 3 candidates. Next slide, please. So she had dyslexia and was emailed the interview questions 15 minutes before her interview to give her time to prepare as by way of a reasonable adjustment. But she wasn't told about this, so she didn't see them. And she did badly compared to the other candidates and was informed that she hadn't been successful. She raised a grievance about the conduct of the interviews and the redundancy process as a whole. The process was then put on hold to deal with her complaints. She argued that she should have had the questions 24 hours in advance. The employer refused and said it was a reasonable adjustment, but they offered to re-interview her because she hadn't seen the questions. Let's carry on then, Lisa. She then appealed, and her employee said that it was prepared to extend her interview by 15 to 30 minutes and to receive a summary of the competencies against which she would be assessed 24 hours in advance. And she would be given new questions. Now, within 2 hours of receiving this, she sent 3 emails to the appeals manager taking issue with the decision and wrote 3 further emails to the chairman of the organisation complaining of the decision. She was then given 4 options to resolve the situation, including one that gave her the interview questions an hour beforehand. The employer also told her that her email suggested that she didn't have trust in the grievance procedure. And I see this quite a lot, and I've had a few cases like this with individuals, even after the final stage of a company process, sending further dialogues, sometimes vast in the words she used and the quantity of pages, being objectionable about the process. Mrs. A responded by way of a 5-page letter, and then she alleged she was refusing to give her the questions 24 hours in advance of the interview was discriminatory. And as you will know, lodging a discriminatory complaint is itself a protected act. By this point, I think the company were just really frustrated. They were trying to progress a matter. They tried to make some reasonable adjustments, and her persistence to challenge that was felt to be disruptive. So she was invited to a meeting to decide if her continued employment was tenable. And questions were raised about her perceived unmanageability, the fact that she had persistently and repeatedly complained that of issues that had already been dealt with aligned to their processes, the time it was taking to deal with those complaints, and ultimately that trust and confidence had reached a point where the relationship had broken down. Now, in that instance, her employer dismissed her for SOSR, concluding that there were no viable alternatives. And Poppy will pick up on that last point, it's really important, about whether there is a viable alternative. So the question is, was the dismissal unfair? Well, you might be surprised to learn, or maybe not, that it was found to be fair. Now, this is a case from last year, Alexis and Westminster Drug Project. In that case, the tribunal, excuse me, found that the reason for dismissal was because of her response to the grievance appeal outcome. So there are some risks with this because she is disabled. She's perfectly entitled to raise concerns about the lack of reasonable adjustments as perceived by her, and she's absolutely entitled to allege discrimination if she feels that that is something that she's been subjected to. And she's entitled to not suffer less favourable treatment as a result of raising that complaint. However, there is a fine line, and she went one side of it here, in terms of how you then deal with that complaint. There are internal processes and procedures in place for dealing with these things, and she would not allow those procedures to be a basis of considering her concerns and accepting them. So it was this unreasonableness in terms of how she responded to that grievance that ultimately was her downfall, leading to the tribunal accepting the employer's evidence that the relationship had become unsustainable. The employer was able to demonstrate through evidence that the relationship was irretrievably broken. And there has been a couple of questions in terms of what evidence is needed there. And it really is very fact specific, but sometimes you will get into a situation where not only do you have an investigation, but the investigation would include statements being given from key stakeholders. Obviously, you need to make sure that's entirely objective, and Poppy will pick up on some of that. But in terms of the evidence, it really does come down to showing that it has been irretrievably broken, and that was established in this case. And then procedurally, you need to make sure it's a fair process. And again, Poppy is going to speak on that in a moment. So that's that case, and I'm going to move on to my next slide now, please, which is third-party pressure. So you've heard about personality clashes, you've heard about trust and confidence issues, you've heard about how tricky it can be sometimes to find the right way of dealing with these situations, and this is another one that comes up quite a lot, actually. where there's often a grey line, grey line in terms of whether it's a conduct issue and whether you've got enough to dismiss. And it's particularly difficult here because you've got the added complexity of sometimes some commercial relationships that you want to keep maintained. Yet, if you do not do what they're asking, will that be the case? So there can be circumstances where the substantial reason is the pressure by a third party to dismiss the employee because the relationship was broken down with a third party, perhaps who that individual is needing to work with. Now, here the focus is on the importance of the relationship with the third party and the consequences of not complying with their request. That's the key thing here, rather than whether you as an employer have a breakdown in the relationship with your employee. So you must consider the potential injustice to the employee. So if I'm the employee, someone has complained about me, a third party, perhaps I work on their site, somebody has complained about me, and what is the injustice to me if I am then dismissed as a result simply of that complaint by the third party? Can you persuade the third party to change their minds? These are all things that you should be able to demonstrate as part of reasonable steps to avoid dismissal. If they will change their minds, perhaps by addressing the issues that they've complained about, that might be one way forward, and obviously is less draconian than a dismissal. What do the services in the contract say? Is it necessary that they have that one particular person? Can you easily swap, and can you therefore redeploy the individual elsewhere? Are there any other roles that the employee can do? All of those kind of things need to be factored in, and it will not be a fair dismissal under SOSR on the grounds of third-party pressure if you do not explore fully with the third party what the issue is and how it might be alternatively resolved. Now, we do need to be really careful here because I'm just doing one more thing before I come on to tricky issues. We do need to be really, really careful here because there are instances where third parties may well raise issues that themselves are going to be a concern for you if you act on them. And here I'm thinking in particular, now you can move on to the next slide, Lisa, thanks, where the third party perhaps makes a judgment against somebody because they have done a protected act. Perhaps they have made a concern of sexual harassment against one of the third party's employees, and that's the reason why they don't want them on site. Now, if you were to condone that and then take that forward, are you then repeating that discriminatory and victimizing behaviour? You've got to be very clear about what is the genuine reason behind the dismissal. And that's the case whether it's third party or whether it's something arising from one of your own employees raising concerns in relation to an individual. So on this slide, I've just put some red flags really. So the kind of questions you need to be really thinking about, and let me just pick out some further ones here. So is the dismissal really a cover up for a discriminatory or automatically unfair reason? Does the employee have a protected characteristic such as race or religion, which has caused the problem within the team? If so, it goes without saying you need to be extremely careful because this is going to be a high risk discrimination scenario. And really there we need to understand what is happening and why. And it may be there is a justifiable ground for dismissal, but there's also a high risk of a discrimination complaint. And you will know that some discrimination complaints can be capable of justification if it's a form of indirect discrimination, but some are not. So that really comes down to what is happening. Have they rejected a colleague's sexual advances? Is that the reason why somebody's now alleging that there has been a trust and confidence breakdown? What has happened in the background to that relationship? Do not just take at face value what one person is particularly saying about another individual. Investigation and understanding the background is really important. As I've mentioned already, they might have made a protected act themselves if they've lodged a discrimination complaint, or indeed they might have blown the whistle on wrongdoing. And there's a number of examples where people may have blown the whistle and then been subjected to an SOSR type scenario, either soon afterwards or in circumstances that then follow, which from a causation point of view could be picked back to the blowing of the whistle, so that we could, the tribunal is likely to say, actually, had they not done that, we wouldn't be in this position of a trust and confidence, and therefore the only reason that you have dismissed is as a result of the fact that they have made a public interest disclosure, blown the whistle, or raised a protected act. Now, if you can separate that, like I've alluded to, and like Laura's also alluded to, so it's not the fact of that complaint, it's the manner in which they've persisted, there may be grounds in which you can then justifiably rely on what's happened subsequently to fundamentally break down that relationship. But it's a really fine line. And what I would say is that you absolutely do need to take some legal advice to get this right, if it's not clear and if you think any of these things are in the background. And on a related point here, we've had, I've had a few cases like this in the last few months where objectionable behaviour may in itself be rooted by a disability or perhaps a religious belief or protected belief. So we know that from a protection of what amounts to a religious belief that is protected under the Equality Act, that could be fairly objectionable as a belief. And just because you don't agree with it doesn't mean to say that that can be used as a grounds for either conduct or undermining trust and confidence. There has to be a high level of tolerance to difference within organisation. But like Laura's talked about, there's personality traits which can cause real problems, and some of that might be rooted in disabilities, whether a mental health condition or perhaps neurodiversity, and some particular traits in terms of how people like to be communicated with, how they think and how they operate. And perhaps it's just a clash in terms of the management style, in which case one alternative solution might be to look at different managers and or training to try and understand and unpick what's happening and how people need to work together better and more collaboratively. And all of these things need to be explored before you ultimately rely on SOSR. So on that note, I'm going to move on to the next slide. And I'm going to hand over to Poppy, who is just going to talk about now the alternatives to dismissal, which is so important if you are to be able to justify a fair SOSR ground. And while she's doing that, I'm going to look at the questions which I can see have been coming through. So we'll have some time, hopefully, just to deal with some of these. Poppy.
Yes, so we've obviously now explored that there needs to be a potentially fair reason to dismiss and that you need to be able to just justify that dismissal. And as part of that, you need to be basically questioning whether the ultimate decision to dismiss is reasonable in all of the circumstances. So the statutory test of fairness requires that you act reasonably in treating that reason for dismissal as sufficient. And that will include considering the circumstances of the case, the size and the administrative resources of the employer's undertaking as well. And larger employers are generally expected to do more than smaller employers, but particularly with SOSR and where you're dismissing someone, it's really important, no matter what size, you're considering alternatives to dismissal before reaching that ultimate decision. So the slide sets out some alternatives that you might consider. There are others, and this isn't an exhaustive list, but these are some of the more common ones that we do see. So, for example, where there's a breakdown in the relationships between two employees, before deciding to dismiss one or the other, the employer must take reasonable steps to try and improve that relationship so that it can be said that not only is there a breakdown, but also that that relationship is irremediable. So an attempt to mediate, for example, with an independent mediator might help this, and it might repair the relationship. But if it doesn't, it also shows that you've really tried to repair that relationship and it just can't be done. So that's also a really good alternative to dismissal, and should be taken or considered before. You should also consider whether it's possible to redeploy one of the employees involved in the conflict, or, for example, could you change the employee's reporting line manager? So that is quite a common one that is considered. And again, it will depend on the circumstances, the size of the organisation, and also the employee's particular role and their duties, and whether there is anyone that can line manage them. But it's absolutely something that you should be considering before reaching the decision to dismiss. And as I say, if it doesn't work for the organisation, it isn't required that, for example, you change the employee's reporting line manager or you change their working pattern. But if you don't go down that route, you need to make sure that you're keeping clear records of the fact that you've explored that as an alternative, and then ultimately the reason why you decided not to go ahead with it. And the same's true if you have attempted any alternatives and they've not worked. Just make sure that you keep record of that as well. If we can move on to the next slide, please. So the fairness of a dismissal for the reason of some other substantial reason is judged on the entire process, including whether the employer's investigated the issue, warned the individual if it's appropriate to do so, consulted with the employee, held a meeting to discuss the reasons for the dismissal, and also provided the employee with the opportunity to express their views. So all of those things are quite important in any process. There is some confusion regarding the process that should be followed where dismissing for some other substantial reason, and the case law is unhelpfully confusing. But just for context, and this might be helpful, in the case of Phoenix House and Stockman, the Employment Appeal Tribunal held that the Acas Code of Practice on disciplinary and grievance procedures does not apply to dismissals for some other substantial reason involving an irretrievable breakdown in the working relationship, but that's provided there's no misconduct alleged and the capacity is not an issue. So the Code of Conduct doesn't explicitly cover SOSR dismissals, but certain elements of it might be relevant. For example, and as was touched on previously by Laura, if there is a potential misconduct issue, that's when you'd be wanting to consider and follow that Acas code. But if it is just a breakdown in the relationships, you might not necessarily need to follow the full process for the Acas code. And other cases have supported that. So, for example, there are some tribunal cases that have said that the code applies where the employee is culpable for what has happened, and there is a risk, for example, of a relationship breakdown because of the individual's own culpability. And the key factor and the question you need to be considering really is whether disciplinary proceedings should have been followed in that case. And again, that's something that was explored by Laura in a bit more detail, but it is just identifying the correct process in the circumstances. If you are considering a dismissal for the sole or principal reason of some other substantial reason, it will be safest to investigate and appoint a suitable person as the decision maker, and that needs to be someone that's independent, really. That might be the line manager, or if there's been a breakdown in the relationships between the employee and their line manager, a more senior manager. You need to be warning, consulting the employee for the reason for the dismissal, and hosting a meeting with the employee, giving them the opportunity to express their views. So in that meeting, you really ought to be letting them know that their employment might be terminated as a result as well. And it's usually safest to allow them to have a colleague or a trade union representative attend that meeting with them. And again, in that meeting, it's really important that you're discussing with the individual the alternatives to dismissal, and make sure that that's in the notes from the meeting as well, that you've really considered alternatives that maybe you hadn't initially thought of, but the employee might suggest as well. And then ultimately, after the meeting, you would be looking to inform the employee of the decision in writing, just to show that you've taken some time to consider what was discussed, consider the employee's representations. And then usually, and it will depend on the circumstances, it is safest to give the employee the right to appeal. So there has been some case law that says that only in exceptional circumstances will it be reasonable to take the view that following these steps that I've just discussed would be futile and could not alter the decision to dismiss, therefore dispensing of those steps. There are some cases where that's applied and it's just been completely futile to follow the process, but it is very rare. And so I'd always recommend that you take some legal advice before proceeding to dismiss without any sort of process. Okay, if we could move on to the next slide, please. So just to summarise some of the session's content, really, where an employer is considering dismissal on the basis of some other substantial reason, whether that be due to personality clashes, third-party pressure, loss of trust and confidence, it's vital to be establishing whether there's more than one reason for the dismissal. So that's the first point, please, Lisa. Is one of the reasons for dismissal potentially discriminatory or otherwise unlawful as well? So you need to be questioning that as part of that. Then the next point is to consider, if there is more than one reason for the dismissal, what is the sole or principal reason? And if the sole or principal reason is some other substantial reason, are there other factors that need to be explored or taken into account? So have you really considered and investigated the cause of the breakdown, for example? And then the final point is, having investigated the cause, can you explain the factual background to the potential dismissal? And having done that, is it still SOSR or is it something else? That's all from me, I think. So, oh no, Next slide, please. Thank you. So continuing on the theme of key takeaways, and just to reiterate the fair procedure that we covered previously, once you've established that fair reason, you need to make sure that you're following a reasonable procedure to show that it was reasonable to dismiss as well. So again, just to reiterate, you need to be making sure that you're investigating, appointing a suitable person to act as a decision maker, warn the employee that they might be dismissed, hold a meeting and give them the opportunity to respond, consider all the relevant factors and whether there are alternatives, which we've discussed in detail, inform the employee of your decision, allow them to appeal and keep a detailed record. So just a helpful refresher on that process there for you, and a useful tick box slide for you for future reference. So I am actually now handing back to Jenny. So thank you very much.
Thank you. So we've got just over 5 minutes to deal with some questions. So thank you very much for those that have submitted. There's some that are very specific, so I'm going to focus on the more general ones, but I do invite you to contact either myself, Laura, or Poppy after this if you do have a specific question that we haven't answered and you'd like us to chat it through with you. We'll do our very best to deal with those. So one running theme, I've kind of tried to take the running themes through the questions. A few of you are asking whether there is a 2-year time service requirement in relation to SOSR's dismissals, and there is. It's just like any other form of unfair dismissal. So, you know, you've got your conduct and performance, obviously, and redundancy. They need 2 years service. So does SOSR. With the exception, like any other dismissal, if there is any element of whistleblowing or discrimination rooted behind that SOSR reason, then you could face, well, then you need to be cautious about that, because individuals could bring a claim. And of course, without any further service. And of course, next year we will be having day one rights. So from that point, there isn't going to be service prerequisite in order to bring a complaint. So a few of you are asking in relation to that. Obviously, having difficulties with new employees is what I'm getting a sense of. So within the first year or so of the relationship, individuals that you know just aren't right for the organisation. On the face of it, that could be grounds for an SOSR, but on the face of it as well, they wouldn't necessarily be able to bring an unfair dismissal claim because of lack of service, subject to what I've said about those cautionary points on discrimination and other such types of claims which don't need service. A few of you have also asked about the extent to which you can tie this up with settlement discussions, and I think there's no magic to that really. It's essentially the same kind of approach that you'd take whether there was conduct or performance issues. You can open a settlement conversation on a without prejudice and protected conversation basis. There's nothing stopping you doing that, but you shouldn't do that in such a way that you are then prejudging the outcome of the more formal process. You've always got to factor in that settlement discussion might not go the way that you want. I would say quite a lot of these scenarios often do end up in an alternative discussion around a mutual exit. So you can explore that by all means. Here we are talking about a dismissal which ordinarily would be with notice. Some types of conduct scenarios might be without notice if they're sufficiently serious. So you've always got to factor in notice as part of any such discussions, as well as then ordinarily you'd need some type of additional payment. But we're here to give you advice on that if you're in that situation. So do get in touch if you want to unpick any of these kind of things and strategies. It's quite common that clients will get to a point where they know that they're facing this situation and just need a conversation, so we can unpick some of that and help you agree a strategy going forward, whether you've reached that threshold, whether more needs to be done, whether more evidence is needed to be collated, or whether we can support you with some strategies around settlement. There was some questions in the chat about the extent to which people demonstrate these negative behaviours when they're bringing grievances and complaints. And one thing I'd just like to say on there, that we've got to recognise that when people are going through a disciplinary process or being performance managed, they will naturally suffer an element of stress, and stress can make people act in a way that can become a bit more confrontational than perhaps they might otherwise be. It can make them feel more agitated, and I think you need to take that into account. So what we're talking about here in terms of the manner in which the complaint is brought is something much more than that. You've got to accept a certain level of tolerance of upset and disruption. We're talking about the more extreme form of objection, that absolute insistence that they're not listening to anything that's been said, they're disregarding the internal processes that you've got, and they will keep chipping away and being objectionable. So just remember about that level of tolerance, and that indeed came out of a recent tribunal case from a conduct case, where the tribunal clearly said that an employer does need to account for an element of stress by an individual in the way that they might be behaving during these processes. Some of you has asked whether you can rely on SOSR where somebody has made a complaint, be that whistleblowing or grievance, and it's untrue. And on that, I would express caution, because they have a right to, a statutory right indeed, to bring a complaint and for that to be heard. And if there's always this fear that if it's not substantiated, that they might then be dismissed and trust and confidence is undermined, we're not going to get to the point where people are supported to make those complaints. However, there are some instances, and again, these are more exceptional than routine, where people may, for dishonest reasons and malicious reasons, bring complaints, perhaps to create trouble. And in some of those instances, yes, that trust and confidence might be undermined. But again, you've got to unpick it from the fact that they've brought that complaint, and the fact that it was unsubstantiated is not in itself grounds for the trust and confidence grounds of dismissal. Someone asked if the employee alleges trust and confidence has broken themselves, and in terms of inviting a settlement agreement, is that going to be enough for them to respond by dismissing? I think here what you're saying is they've invited a settlement, they've made some accusations as part of trying to get that settlement going, and you want to then use that. Well, really what you're going to have to establish that the trust and confidence is mutually broken. Just because an employee has alleged that doesn't mean to say there is sufficient grounds. That to me is either more a tactic on their part for approaching a settlement discussion, or if it's done in a more formal way, is just a grievance and needs to be dealt with like any other grievance, so you can understand what their perspective and try and reach a resolution. What we're talking about here is where you can't get that resolution, and despite having gone through those internal processes to try and address concerns raised, you're still not getting anywhere with the relationship being workable. And if we take it right back to basics, you know, we've talked about the implied the implied duty of trust and confidence. You have a right to expect your staff to work with you in good faith, and they have that right of you as well. So ultimately, what we're wanting to get to is that we can work with our employees and expect them and trust them to do the job they are employed to do. But along that, we have to accept people are human, and there will be issues along the way, be of conduct, performance, or absence nature, and there are certain procedures for dealing with those. This is a catch-all at the end, not to avoid those processes, but as a means of unpicking those scenarios which don't easily fall into those, but is a necessary consideration where the relationship is unbroken. And just finally, I've got 2 more minutes to deal with 2 more points. Are the slides going to be shared? Yes. What happens when someone's got criminal charges and they're off for a long time? What happens where you're wanting to change terms and conditions? Does SOSR come into play there? Yes, it does. SOSR is not just these type of scenarios we've covered today, and it's a massive topic, and there's quite a lot to it, which I think you will have seen. But there are instances where you could say SOSR is some other substantial business reason due to the fact that somebody's off for such a long extended period of time and you don't know when they're coming back, such as in the criminal allegations, or in very specific situations where you're wanting to dismiss and re-engage on new terms. That might also be an SOSR type dismissal. We weren't talking about that today because we were focusing on the tantrums trust issues that we started out with. But if you're facing those scenarios and again want to chat with any of the Owen Mitchell team, including myself, Poppy and Laura, please do get in touch. After the event, we're going to send the slides out and a recording. Please share with your colleagues if that's going to be useful for you. Please do sign into our newsletters if you don't already receive them. We do an education specific one for our education sector clients and a more general employment one too. The link is on the slides as well to our podcast, which runs regularly and just comments on all sorts of up-to-date issues, topical legal developments, and is well worth a listen. And we have a regular events programme, and we'd love you to keep in touch with us. Like I said at the beginning, there is a feedback form which is going to be pasted in the chat now. Please could I ask you just to take a couple of minutes to fill that in? It's just a few questions which will really inform how you found today, what else you'd like to hear from us, and if we did in-person events, where might you be interested in coming to those? In addition to these large-scale sessions, we also do some additional more smaller group sessions which have a bit of conversation between us, and you've got an opportunity to show an interest in those too. So if you could just sign on and do that for me, I'd be very, very grateful. And then finally, our contact details, again, are on the front of the slides, but also will be in the email following up just to send you a copy of the video. So it's 11 o'clock. On that note, I'm going to let you go and enjoy the rest of your morning, but thank you ever so much for dialing in. It's been lovely to have you all, and I hope you found that informative and helpful. Thank you.